The Supreme Court, our nation's highest court, is about to hear one of the most significant cases pertaining to abortion probably in 30 years, going back to Planned Parenthood versus Casey. This case could overturn Roe v. Wade as we know it, or significantly limit its judicial reach. The name of the case is Dobbs versus Jackson Women's Health. It comes out of Mississippi. It is about the 15-week abortion ban that the state of Mississippi passed. Now, Planned Parenthood and their ilk are, of course, hoping the high court will eventually strike down this common sense state law. FRC has submitted an amicus brief, or what's called a friend of the court brief, in this case. And here to talk about this case and FRC's involvement is Katherine Johnson. She is FRC's Research Fellow for Legal and Policy Studies. Katherine, welcome back to the program.
Thanks for having me, Tony. It's great to be here.
All right, before we get into FRC's brief, last week the state of Mississippi, the Attorney General, Fitch, introduced or submitted their brief, and it was an extremely strong brief going really at the heart of the matter, and that is Roe v. Wade. Tell us about it.
It was an incredibly strong brief. You know, there was a lot of speculation. Nobody knew what Mississippi was going to do, what approach the Attorney General would take. We were hoping that she would ask for Roe to be overturned. We didn't know if that would be in the form of a little footnote somewhere, but the Attorney General and the State Solicitor General, the top lawyer for her, came out incredibly strong. The entire brief was attacking Roe. It called out Roe for what it is, wrong. It was wrong from the beginning. It's wrong today, and it's done irreparable harm to our country, and there are lives lost as a result. So the brief went straight to the matter. It came out striking at Roe, and now it's in the hands of the court. And the court can't say that Mississippi didn't ask them to overturn Roe, which is something Justice Roberts said in June Medical, the last abortion case. So we're very, very excited and appreciative to the Attorney General.
So, Katherine, what approach did FRC take in our brief to the court?
So yeah, we filed an amicus brief just today, and we said that the undue burden, the viability standard in Casey is not workable. And similar to what Mississippi said, the undue burden standard was wrong in the beginning, and it was wrong today. So states should be able to protect children before viability. Viability has no marker in the Constitution, has no reasoning in the law. It was an arbitrary standard that justices on the Supreme Court made up. So we're calling for the viability standard to be removed.
And then it does go to the states. The states would then have the ability to set that policy for their state?
That's right. And what would most likely happen in Roe and Casey being overturned is this would become a state's issue. So one state, let's say Mississippi, could protect the unborn at conception, and California could still legalize abortion all the way through pregnancy. But what the court has done in Roe and Casey has removed any state's ability to fully and holistically protect the unborn. And something else we argue in our brief is the viability standard removes any other interest a state might have in protecting the unborn, such as approaching and ending the use of abortion as a use of eugenics. So the Roe and Casey forbid any other reason to protect the unborn. And so we argue that states should have other interest in protecting the unborn.
I mean, it's been 2 decades or 2 to 3 decades before the court revisits this issue. So you had Planned Parenthood, you had Roe v. Wade, you had Planned Parenthood versus Casey. I mean, this is going to be in the same league. I mean, this is a significant case. When will oral arguments be heard before the court?
Those will be in the fall, and we're hoping for an opinion in January. And that's exactly right. This is consequential. This is actually the first gestational limit, 15 weeks that the court has heard since Roe. So there's really no emphasis. You can't overemphasize just how big of a deal this case is.
And we've learned so much, in part by technology. We've seen society change its views on this. I mean, unlike what the court wanted in Roe v. Wade, this issue has not gone away. They've not solved it. It's more of an issue today. The court could have the chance to resolve the political nature of this by sending it back to the states and let the laws reflect where the people are.
That's right. And actually, a lot of other amici before the Supreme Court have argued just how out of line the United States is in their abortion stance. There are very liberal countries in Europe who forbid abortion after the first trimester at 12 weeks. Mississippi is only asking for 15 weeks. So we really do point out just how extreme the United States abortion jurisprudence is and how out of line it is.
Katherine, thanks so much for joining us and bringing us up to date. Obviously, this is something we'll be talking about quite a bit over the next few months.
Thanks for having me.